SJC-12777, Freddie Carrasquillo Jr., and all other similarly situated defendants in Hampden County, v. Hampden County District Courts.
Ms. Jacobstein, good morning.
Good morning, Your Honors. Rebecca Jacobstein on behalf of the named petitioners, but also in light of the questions raised in the reservation report, CPCS. We're asking this court today to do two things. We're asking this court to declare Judge Payne's order unlawful and unconstitutional, and we're asking this court to exercise its superintendent's powers to provide resources and administrative assistance to the Springfield District Court. When faced with a shortage of counsel in the arraignment session, Judge Payne may have had no good options, but of the options he had, he chose the worst one. He put the needs of his courthouse above the constitutional rights of indigent defendants. He placed the systemic problems on the backs of our clients. This was both unlawful and unconstitutional. Under 211D, Judge Payne was required by statute to assign CPCS.
Okay, so if he'd done that and not assigned that particular lawyer, has he fulfilled his constitutional duties, done a good job, and actually produced a great result here? Or,
Your Honor, it's never a great result the day that we can't provide counsel at arraignment, ever.
But now you are.
That's where we find ourselves, Your Honor.
But you find yourself, it looks like, having solved the problem, at least temporarily, right?
Currently, we are able to assign counsel at arraignment, yes. Mm-hmm. But that doesn't change the fact that Judge Payne's order was unacceptable. It deprived the people who were being arraigned of their right to counsel at arraignment. It deprived our current clients of the right to counsel because our attorneys were being overloaded with cases and forced to appear in the arraignment sessions all the time. So what Judge Payne had to do was he had to assign CPCS. No one wants to provide counsel at arraignment more than CPCS does. We are not here for the money and the glory. We are here because we believe that it is our job and important, and it is our goal to provide counsel, meaningful counsel, competent, qualified attorneys at arraignment and throughout the representation to every client.
Isn't the issue also that if somebody on the staff has, I don't know what your number is, but let's say there's 25 felony cases that they are defending, there's a point where case number 26, taking that, is actually professional responsibility rules would prohibit you taking case number 26 because of the impact on the other 25. Isn't that implicit in all of this?
Yes, absolutely. Our caseload capacity is determined by our ethical responsibilities, the client's constitutional rights. I say this because it is true. It is a very context-specific, individualized determination made by the people who know, which is the supervising attorneys and the attorneys in charge. We know what local practice is like. We know where each attorney's caseload is at that moment, the numbers, the types of cases, what's coming up. Are they going on leave? Is somebody else going on leave and we need to transfer their cases? There's a huge host of factors that go into that determination.
Let me just go back to, you said that Judge Payne made the worst choice of bad choices. What would have been the best choice for him? And then if you can just explain what you would like to see happen so that when this happens again, they can make the best choice.
Sure. What we wanted Judge Payne to do was assign CPCS, the agency, not the Public Defender Division. Then what we suggest that should have happened, and we suggest this also should happen going forward, is that people who are not held are brought back within 45 days, and if we haven't provided counsel, their cases are dismissed without prejudice. If they're held, they need to be brought back every day because we agree that that case is the priority case. So they need to be brought back into court every day to see if we can get them counsel. And at 7 days, if we can't get them counsel, they are to be released. Because it's not their fault.
Can I ask you about when the bell gets rung as far as the constitutional crisis goes and how we determine whether it's a constitutional crisis? So, and I get, and I've read the very fine briefs that just determined or describe the individualized determination of caseloads. In one case involves DNA, one case, not all cases are the same. I certainly understand that. But it can't be that CPCS says there's a constitutional crisis, we've reached our max, and that has to be taken as gospel, and a judge or someone reviewing it can't say, well, let me look at the numbers, because the private counsel offers a 250 case limit. I forget what the number is, but there's a case limit for private bar. Shouldn't a judge be able to say, all right, you've said it's a constitutional crisis, and in good faith, I'm sure you believe there is, but let me look at the caseloads to see whether or not I agree with that? Or is that just completely sacrosanct and we have to say there's a constitutional crisis when your agency says there's a constitutional crisis?
I think that Your Honor is putting forth two kind of distinct issues here. I think that, one, we are doing good faith, but if this court wants to review good faith.
I'm not suggesting you're
Right,
not.
if this court wants, or if the judge wants to review our good faith efforts, fine. Within the 7 days for the held people, within 45 days for the 45-day people, no problem. But whether or not we have good faith, I think, is whether we have done our parts, and we have, should not be attributed to the defendant. I mean, it's his constitutional rights.
Right,
He doesn't sit in jail because you're like.
But a judge should be able to make a determination in a hearing as to whether or not you've reached you're overloaded and whether you've reached your caseload max.
Certainly, I think with a lot of deference to us, we do have expertise in that area.
Right.
That this is our bread and butter.
Right, I'm not saying, it's not like the bat signal where all of a sudden you light up the bat signal into the constitutional crisis, but there should be a factual determination as to whether or not you've reached that.
If a judge wants to make that determination, that's fine. I don't think that it is necessary. It may be necessary for other reasons, but not for an individual defendant to get relief, because that defendant deserves the constitutional rights regardless of CPCS's good faith efforts, which are always there.
So CPCS undoubtedly has good faith efforts and undoubtedly has the statutory responsibility, and sometimes the burden's too much. And I'm sorry, this is going to sound like a rhetorical question when I don't mean it as a rhetorical question, but where's the rest of the bar? I mean, there's a lot of lawyers and a lot of law firms with a lot of resources, and we've got this crisis out there. I don't mean real crisis, but lawyers don't try cases anymore. A very small percentage of lawyers don't try cases. Where's the rest of the bar? I mean, there's a problem.
There is a problem.
So shouldn't the rest of the bar stand up too?
Well,
Recognizing it's your statutory obligation, I understand that, but there's a solution.
we are happy to train and support any attorney who's willing to come forward to take
When
cases.
Judge Payne has no good option, you can't give another case to somebody who's over the limit of where they can provide ethical, competent responsibility. You can't let criminal defendants be unrepresented when they're facing 58 A's or in almost all other situations. So there needs to be a solution outside of that dynamic.
Well, I mean, I think it's also important that we recognize that we can't force bar advocates to take cases they don't want to take.
Right.
That would be a
Put
taking.
that into my question. Good point.
I mean, right, because that would be a taking, and we at CPCS would not want non-criminal defense attorneys to suddenly be coming in.
Oh, the training's pretty good. The CPCS, for the bar advocates is pretty good.
I mean, we have a system set up, and, it's 211D sets forth, a nationally recognized system with independence from the judiciary, performance guidelines, oversight, private bar and public participation. It's a great system.
I'm not saying lower the bar to what it takes to represent indigent defendants by any means. I'm just saying that maybe the burden needs to be shared. It's a profession.
But in this case, the process, there were problems with the process, but back to Justice Budd's question, because I'm very curious sort of where we go.
Yes, I think I missed the second part.
So the first part of it, the judge should have ordered CPCS rather than that particular person. Then CPCS here creatively responded. They created the $424 a day duty lawyer, and then the actual number is reduced to, we have, what, 3 lawyers were not assigned at this point? And 3 defendants were without counsel at that point? Is that?
Yeah, at one point, we're down to
Consequently,
0.
all unfilled day slots were filled in August and September, and CPCS extended to November. Additionally, the number of district court defendants without counsel decreased from 169 in July to 3. So it sounds like that was the proper next step, right?
What was
Proper next step, the judge, CPCS did just what you said, stepped up and did a great job and figured out what to do. So we didn't have to do anything else except for what Justice Budd did, which was put the LaValle protocol into play. So tell us how to do it better next time, or compliment us for doing a great job.
Well, I'll start with the great job on implementing the LaValle protocol. I think that what we're looking for next time is it's in a more immediate response. You know, in the previous argument, the question was, how is this systemic or is this a crisis? I think that the way I look at it is not, is it systemic, is it system-wide? Is it systemic, is it caused by the system? So any individual defendant, even if the reason that that defendant doesn't have an attorney right away is because there's 6 attorneys in the courtroom and all of them, for whatever reason, have a conflict, you know, they need to keep coming back. So what we're asking for is, you know, what we do say is that if the LaValle, we kind of want LaValle, at least the 2 parts with the release of the defendants and the dismissal of cases, to be self-executing. So, you know, in the best of all worlds, we would notify.
By the way, back to the chief's distinction, the protocol or the remedy of LaValle?
Just you know, the remedy for the indigent
So you
defendants.
want to put the remedy ahead of the protocol?
Right, because the purpose of the remedy is to protect the constitutional rights of the indigent defendants, and that's what we're trying to do here. I mean, the
Okay,
big picture is to get the lawyers.
the fix you want is us to now not do the protocol first, but the remedy first, and then the protocol? That's how you would do this better next time? Meaning dismiss without prejudice a bunch of cases that have gone on 45 days and immediately release the people facing the dangerousness proceedings in the interim. Is that, I'm not being
No, I mean,
rhetorical,
that is
I'm
what I'm
just
asking for. I think what we propose in the brief is that up until the point, you know, now that we are in several counties on the precipice, what we're suggesting is that when we at CPCS see that our caseloads are becoming to a point where we are not going to be able to take in-house cases very soon, that we notify the courts and the district attorney's office and say, look, we are going to be reaching our case cap soon. We still have room now. So what we're going to do is we're going to allow you to triage your cases. We'll send all the cases to the bar advocate program, but if the bar advocate program can't cover, now your 58As, because those are the only ones where there is in fact a public safety concern, the 58As, you come to us, and we will definitely have space. You know, in places where there aren't as many 58As.
You like that better than kicking in the protocol and saying, immediately call in every case that we don't have a counsel and get them counsel. And instead of dismissing the cases, you know, I'm just not sure this is workable, what you're talking about. So CPCS says we're not going to do it. The prosecutor has to triage their cases and the court has to triage their cases. Is that what you want us to say? Because that's running into some separation of powers questions.
Well, what we're saying is that, let's say we have, I'm just going to pick a number, that we have about 10 cases we can take before we'll have we can't take cases anymore, office-wide. We can either, consistent with the public safety concerns that are noted in La Valley, we can say, well, we'll take the next 10 cases coming in, or we can say, look, your call. Which 10 cases do you want us to take? Do you want us to take the next 10, or do you want us to stand back? Those trespassing, shopliftings, uttering a bad checks, we'll send to the bar advocate system, and then with 58 A's, you send to us, and we'll maintain space for it. Otherwise, and then if that becomes overwhelmed, then we go back to La Valley, which is the remedy portion.
You don't take the trespass and bad check cases.
CPCS, our district court, yeah, we do.
Oh, really?
Oh, yeah, no, I mean, we take what comes in the day we're at the duty day.
Let me ask you something, though. When you're saying we've got max 10 cases, because I assume that this requires two things. One is a dialogue, as far as you're saying we've got 10 cases, but it's also going to require transparency. So if I was a Superior Court Raj, for instance, and this came to me, wouldn't I say, well, I actually think you can take 15 cases based on your caseload? Isn't there room for that?
I don't think there's room for that until until we can't take cases anymore, right? I think that up until the point we call it, it doesn't matter. Then once somebody is bound to be released, if the courts wish to hold those hearings, fine. But they need to hold them quickly because our clients have a constitutional right not to be held without counsel.
But what we've learned from your creative way of dealing with this issue is that we don't always have to be on the precipice. There's a clear legislative fix, which is to adequately compensate people for the important good work they're doing. That's the solution, and it's mentioned in amicus briefs. And I know that you're working on it, but we don't have to come up with all these creative ideas if there's compensation that's appropriate.
Yeah, we have consistently and continue to request compensation increases across all of our practice areas to ensure that we can provide effective, competent representation without being on the precipice in all of our practice areas. Yeah. And we've also asked for, and I think received some relief in the hourly rate cap, which can become a problem. And then, there's a lot of prongs and a lot of things that go into it, and so we're looking for all of it.
But we can only do what the judiciary can do, and the judiciary can't order the pay increase. So, again, practically, what I gather from what you're saying is when CPCS says we're maxed out, you release the defendants first.
Yes.
Okay, any other suggested changes in our protocol? Do you you want us to make any other changes to La Valley?
I mean, in the best of all worlds, the dangerousness hearings are supposed to be held at 3 days for a reason. I think that they should be released after 3 days. I think that after a certain period of time, the cases should be dismissed with prejudice.
No matter who they are, no matter how dangerous the person is, right?
Your Honor,
I'm just asking,
Yeah,
because we have to live with
we-
the practical consequences of this, so
we
I just want to
stand-
make sure I understand what your position is.
Yeah, that's
And
where we stand.
that's better than ordering a hearing and immediately getting counsel, 2 days later.
2 days later than the 7 days?
Continuing for 2 days and getting counsel.
After the 7, so like 9 days.
What they did here, I'm just focusing on I can't remember if this is the Walsh facts or your case's facts. So the judge continued for a week, right?
So
And then counsel was provided. But again, that was an error in your view.
after 7 days, people should be released.
A constitutional error.
It is, because you have a right to counsel immediately. I mean, the fact that waiting 7 days is a constitutional
I'm not saying it's
crisis.
desirable. I'm just trying to understand, from your point of view, that's one of the fundamental errors of what we've done so
It is,
far.
and especially because you don't know when that attorney's coming. If we knew that the attorney was coming in 2 days, then they'd be there now, right? I mean, it's not that the extra 2 days I mean, the extra 2 days are awful. I mean, this person's incarcerated. But what I'm saying is that you can't know, right? If we had an attorney write that and we knew that we could get an attorney, we'd get that attorney.
Okay, thank you.
Thank you.
Mr. Siegel.
Good morning, Mr. Chief Justice, and may it please the court. Matthew Siegel, representing the amici, the Hampden County Lawyers for Justice and the Massachusetts Association of Criminal Defense Lawyers. For 3 reasons, the guidance that the court issues in this case should include a declaration that the statutory compensation scheme for compensating bar advocates is unconstitutional as applied in Hampden County. First, the right to counsel includes the right to an indigent defense system that reliably delivers lawyers to people who cannot afford them. Second, the legislature has not provided such a system. In Hampden County, the unreasonably and unconstitutionally low rates are leading to regular periodic lapses in the availability of defense lawyers and to the steady collapse of the bar advocate system. And third, as the experience of LaValle itself demonstrates, the legislature cannot reasonably be expected to solve this problem of constitutional dimension unless it is told not only that it should, but that it must.
Can you address, Mr. Siegel, the adequacy of the findings in order to make such a bold call that you're asking for? Because here we've got CPCS coming up with creative solutions, as we're told. We have dwindling caseloads, over 1,000 cases less than in years past, and we don't know, despite the good faith of CPCS, what their caseloads actually are because it's individualized and we just don't have those numbers. In order for us to tell the legislature that what they're doing is unconstitutional, just like in Bragdon, which you're intimately familiar with as Ms. Jacobstein, when we call it something a constitutional crisis, don't we need to have those facts?
I think you do have adequate facts because of the unusual record of LaValle and this case. But I recognize this is probably the most difficult question in the case, so I want to start with the general and then sort of move in. So ever since Powell against Alabama, the standard for when there's a warm body next to a defendant, but maybe not a lawyer, is whether there's truly the guiding hand of counsel, whether that's the touchstone. And here we have a couple of things that tell us that that's going away. One is, notwithstanding that at this very moment, there's perhaps a one-to-one match between lawyers and defendants. For a regular period of time, beginning in the record before you, is that from 2017 into 2018, Hampden County Lawyers for Justice was becoming unable to staff duty days, unable to staff cases in Hampden County. In May, in June, in July, in August and September, there were defendants who did not have lawyers. The fix that's been put in place, again, to CPCS's credit, is not something that our clients reasonably expect to fix this problem in any meaningful way. If we have out-of-state lawyers out-of-county lawyers coming in to pick up duty day cases, pick up 20 cases in Springfield, we have no expectation that those cases will be acceptably litigated, or that those people who came in that one time, which happens to be when this case is being argued, will like that experience so much that they will regularly make the trip from wherever they live to Springfield to pick up cases. So we have no expectation. The record does not really establish a fix in that sense. The second thing is this death spiral that the Bar Advocate program is in. And I don't say those words lightly. It refers to, and it goes to some of the things that the Chief was pointing out in the prior argument. We're talking about, with the record before you, is that there's been a decline in the number of bar advocates who have contracts with HCLJ. The record before you is that there has been a huge, maybe 21% decline in the availability of Superior Court advocates statewide. And this goes not only to the volume of lawyers who can do this work, but to the diminishment of people who have the specialized skills. When we're talking about the departure of the people who have more skills, who can do this work that, as the court has acknowledged, is specialized.
So what's the reason for that?
The primary reason, and that's why I started my argument, just cipher where I did, is the rate of pay. The fundamental economics of this system do not line up. To take a case for $53 an hour, it can become nonsensical when you're talking about an attorney who has to have malpractice insurance, who has to travel, who has to have Westlaw access, overhead, et cetera. One way to think about this is there's one law school that produces maybe 100 graduates a year in the western part of the state. It costs $44,000 a year to go there. If someone tells you that they're planning to go to law school to incur that kind of expense and come out and take district court bar advocate cases at $53 an hour, you probably have to have a chat with them. And so that's why I say, and I realize that the red light is on, but that's why I say that what is really necessary here is not just a request, not just a deference to the legislature to see if it will fix the problem, but to say that it must. And if there are concerns about the immediate effect of such a declaration, there are ways around that. For example, by staying the ruling 60 days so that the legislature can act and so that this court wouldn't need to undertake in the first instance to come up with a rate. But that kind of solution, a delay, would make more sense than to decline to say what is necessary. And what is necessary to say is that these rates are not constitutionally adequate.
Back to Justice Gaziano's point, I mean, the only time I'm aware that this court has ordered the legislature to increase payments, maybe in the education context, that series of cases. There were huge factual records about, the disintegration of education in these particular communities. Can we really do that here? I mean, without, and is there a case where, based on this kind of record, where we're not in an immediate crisis, where this court has ever ordered the legislature to increase funding like that?
Yes, Your Honor, although
Which case? I'm just curious.
So I would agree in the first instance that McDuffie is the best example, not only because of the remedy that the court ordered, but because the court delayed that remedy for the court legislature to act. But in terms of cases with not quite as voluminous a record, we're talking about the Abodili case, in which $500 was ordered based on the court's statutory authority to compensate counsel. We're talking about Department of Public Welfare against JKB, which was termination of parental rights. The court announced a right to counsel, but then simultaneously announced a right to compel that the counsel be paid. And probably Baird against Attorney General from 1977, which is the case about appointing attorney for a minor seeking an abortion. So there are cases, even in the individual case context, where this court has asserted the authority to do the sort of thing that we're requesting. I also want to clarify two issues that have come up, if I might, in the argument today, because I think it's really crucial. The Lavallee hammer is being talked about in this argument today as though it's sort of the best or most that we could do. But I think it's very important to understand that in Lavallee itself, this court was saying that Lavallee wasn't even a remedy for Lavallee, that the remedy that needed to happen needed to come from the legislature. So all I'm talking about today is how forcefully must that be said. And the second thing, I really want to respond to Justice Lowy's point about whether the bar should step up or how it could step up, because I think it's illustrative. We are here today at this breaking point, and this goes to the record, only because there's no more give left in the joints. And the reason there's no more give is that the stepping up of the bar has already happened and is the thing that keeps this going. My client's president and its board do all this work for free. There are law firms that do not have the requisite expertise, but do, for free, represent bar advocates who are subject to bar complaints from their dismayed clients. All the work, the hustle that you see that's in the record, people are devoting time not to representing clients.
I appreciate that, and that is important, and thank goodness it's happened. I don't mean that. I mean the percentage of lawyers in Massachusetts who are representing indigent clients. The program for certification is terrific. I attended it as a lawyer. I have spoken at it as a judge. It's terrific. I'm talking about the percentage of lawyers who are doing this important work. That's what I'm talking about.
Right. Well, I think that's where the problem is, because the compensation rates are insufficient to produce the population of lawyers capable of doing that work. So what you see are these pro bono efforts of people like David Hoos from HCLJ and others to sort of cajole the ones who can do it to do it. But the problem is the pool is running out. And that's why I go back to the request, not just to say that the legislature should do something, but that it must. There's a risk in this case, in talking about protocols and procedures, that at the end of all this work, we will have organized the deck chairs just perfectly so, but we'll still be headed straight for the iceberg. And the compensation rates are the iceberg.
All right, thank you. Mr. Casey.
Good morning, Your Honors, and may it please the Court. Tim Casey, Assistant Attorney General, on behalf of the respondents, the Hampden County District Courts. Your Honors, there is meaningful action that this Court can take in this case to address the shortage of criminal defense counsel in the Hampden County District Courts. But as the parties agree, and as I assume the Court will acknowledge, the Court cannot solve this problem alone. Instead, it requires the cooperation and participation of all parties to the administration of criminal justice in Massachusetts to address the problem. First, the legislature likely needs to be involved. The parties therefore agree that the Court should defer immediate action while the legislature considers CPCS's proposal to increase the rates of compensation for private bar advocates.
What does that mean? Well, I'll let you finish. Go ahead.
Well, Your Honor, it means...
Why don't you give all of what you're asking us to do, and we can go back to that. I'm sorry.
Okay, thank you. The petitioners assert, and the respondents have no basis to disagree, that the most durable and long-term solution to this problem must come in the form of increased rates of compensation for bar advocates. It's worth noting that the legislature has already taken important action this year by authorizing CPCS, in the case of an emergency shortage in a particular location, to lift the annual hourly caps on bar advocates up to a maximum of 2,000 hours per year. CPCS doesn't claim that that will solve the problem, but it does assert, and this is in the record, that it will help. The legislature should be given an opportunity to address the similar request with respect to increased rates of compensation for bar advocates. There are other steps that are meaningful and important that this Court can take, and along those lines, I would add that this Court's written opinion in the case, as it did in Lavallee, can emphasize the importance of the issues presented by this case and can help spur the legislature to act on rates. It's just as it did in Lavallee. It's worth noting, I think, that about a week after this Court issued its decision in Lavallee, the legislature increased the rates of compensation for bar advocates and did so again approximately a year later. So this Court can help that process by reiterating and reaffirming the importance of the issues presented by this case. Your Honors, next I'd like to turn to the June 12th order by the First Justice. Our position, as you know, is that there were simply
Those are the only, are you recommending any other changes, or is that's the extent of what you think we should do here?
Well, Your Honor,
any changes to Lavallee that you think are appropriate?
I think Lavallee represents an important and elegant solution to a problem, recognizing the limits of this Court's authority with respect to a problem that requires the participation of all actors in the criminal justice system.
What about fact-finding? When is there a constitutional crisis, and who decides whether there's a constitutional crisis?
Well, Your Honor, as you know, in this case, after the petition was filed before the single justice, the parties agreed to submit to a Lavallee protocol, which the single justice ordered mere days later. So the parties were in agreement that a protocol, the Lavallee protocol, which was beyond the power of the First Justice to implement as a protocol, needed to be in place here. And so the parties agreed that there was a systemic problem that required a solution beyond simply what this court described as the hammer of Lavallee. Although that did happen in a small number of cases. There is a transcript of a June 14th hearing after the June 12th order where, although the first justice declined to modify the June 12th order, he did release, with conditions, 2 defendants who were held beyond the 7-day limit without counsel.
I guess that raises the issue of whether the Lavallee hammer is a constitutionally required, regardless of whether there's a larger crisis. Is each individual defendant not entitled to be released after 7 days if he or she cannot be given counsel?
Well, Your Honor, here, in fact, the judge did, before the Lavallee protocol was implemented, in fact, release defendants who had been held beyond 7 days.
So we don't necessarily need a constitutional crisis to say that a judge might be required to do that where a defendant's being denied his or her right to appointed counsel.
I think that's possible, Your Honor. I would add that, as Lavallee indicated, before that happens, there has to be a showing of good faith by CPCS that despite its good faith efforts, it has been unable to secure counsel for a defendant in a particular case.
Okay, fair enough.
And, I'm sorry, Your Honor.
No, so basically a judge would say, would have the inquiry that Justice Gaziano arguably was calling for, to speak to CPCS and say, tell me the efforts that you've made, and if I believe that they are satisfactory and in good faith, and the fact of the matter is that counsel cannot be found for this defendant, the remedy is release him after 7 days if he's being held, and after 45 days, order it to be dismissed without prejudice if counsel can still not be found.
Yes.
Is that a constitutional obligation? Is that essentially something we should fashion as a constitutional obligation, regardless of whether there's a finding of a constitutional crisis?
Well, Your Honor, I think it is something that under Lavallee, that is essentially the limit of what an individual trial court judge can do in a particular case. Also of note about that aspect of Lavallee is that it allows for the judge to impose conditions of release, which ordinarily, the court noted, could not be imposed without the consent of the defendant. So those, if that is the kind of smaller framework that an individual trial court judge can implement, then that seems appropriate to say, CPCS, what efforts have you undertaken to find an attorney here? If despite those efforts, counsel cannot be secured, then perhaps this defendant can be released.
And that would account for the triage that counsel suggested as far as the 58A defendants.
That's right, and all parties to the system should be triaging cases. 58A cases should be coming first in terms of the next available attorney should be taking that case. The court...
So we should be adding this Missouri type of triaging approach to the Lavallee protocol?
Well, Your Honor, I'm not sure about that. I mean only to agree with and reiterate what this court said in Lavallee, that all parties to the system have responsibilities in prioritizing their resources and how they're deployed.
Lavallee didn't propose a triage system, right?
Well, the court said generally that prosecutors, judges, the legislature, everyone involved needs to prioritize the use of their resources. It recognized the very real public safety interest that's posed by releasing defendants who otherwise arguably should be held if they're without counsel for more than 7 days, and dismissing cases, albeit without prejudice, if they're pending longer than 45 days.
So the Lavallee protocol essentially is a collaboration and communication protocol, but implicit in that is that DAs would have the good sense to triage cases lest they find cases being dismissed that they don't want to be dismissed. So triage was not ordered by it, but was implicit. It was, I guess, something that was hoped to be the product of the collaboration and communication that was set forth and required by Lavallee.
Yes, I think that's exactly right.
Are we at a stage now in Springfield in which we need to have a communication and collaboration protocol, given the fact that the ratio there are approximately 6.3 lawyers per 1,000 in Massachusetts, but only about 3 lawyers in 1,000 in Hampden County and the western part of the state. And the average debt of a law school graduate in Massachusetts is about $110,000. and we already are seeing a dramatic reduction in terms of the number of Superior Court attorneys willing to be bar advocates. Have we reached a point in which we need, at least in Hampden County, to establish a communication and collaboration protocol, either as established in La Valley or comparable to La Valley?
Your Honor, by a communication and collaboration protocol, are you talking about the weekly reporting of?
Yeah. That's basically what, right, I mean,
well-
that's essentially, that's what, it doesn't call itself a communication and collaboration protocol, but if you step back from it, that's basically what La Valley is.
Yes. Well, Your Honor, that is in fact in place by operation of the interim order agreed to by the parties and entered by the single justice. So there is that weekly reporting. And again, as a credit to CPCS and its creative efforts here, the duty day rate, but also the La Valley protocol and the interim order, we're now at a situation where there are no unrepresented defendants. We acknowledge that is for now, and the solution that's in place right now may not be permanent or sustainable. But the communications that have been happening from the Superior Court Raj and from the clerk's office is that on a weekly basis, there are currently no unrepresented defendants in custody or with cases
Do you want
beyond.
us to keep the single justice order in place? I'm trying to understand what your position is on that.
Well, Your Honor, we think that it may need to remain in place for some period of time. The hope is that after enough time has gone by, and I can't say what that enough time is yet, but after what is to be hoped is multiple weeks of reporting no defendants in custody, no defendants with charges beyond 45 days. And especially after, again, it's to be hoped that there is a more permanent, more structural change that will address this problem, that the case can be dismissed.
But again, I'm just trying to be practical and understanding what so right now we have Justice Budd's order in place. You want us to keep that in place for some time. Now, this court tends to issue its decisions 130 days from the time we hear our cases. So you want us to, 130 days from now, be issuing an order that keeps this in place?
Well, Your Honor, we think and we hope it's not permanent. We do think it probably needs to remain in place for some period of time, the interim order.
And you think that because you recognize that Hampden County is either in a crisis or on the cusp of the crisis? And that unless the legislature takes steps to increase the hourly rates of bar advocates, that crisis will continue?
Yes, Your Honor, that the solutions that are in place right now may not be available as a permanent or long-term solution. And so we realize that, and to CPCS's credit, it has addressed the problem as part of its authority and its responsibility to coordinate and oversee the provision of criminal defense services in Hampden County. But
I don't mean
we understand
to
the
be
duty.
difficult, but it's the Attorney General's position that the La Valley protocol should remain in place after absent a funding by the legislature? I'm just trying to make sure I understand what you want here.
Your Honor, so much of this is, these are
No, I know it's a moving
pieces.
target, and if you don't know the answer to that.
Right, we don't know 130 days from now whether the legislature will have acted, and if so, how it has acted. If we get to a situation where La Valley described itself as a remedy for a systemic problem of constitutional dimension. So at present, we have a situation where on a weekly basis, we're hearing that there are 0 defendants who would otherwise be subject to the La Valley protocol. We recognize that that is because of solutions that have been put into place that may not be sustainable. So where we're at in 130 days, if there has been no legislative action and the duty day rate expires and we're back to seeing the numbers we saw in July or in August, then I think it may be necessary to keep the interim order in place. But we do hope that it is temporary and that eventually it will result in after consistent reports that there are no defendants in these circumstances, that the case can be dismissed and the interim order can be vacated.
All right, I mean, this appears to be one of the few problems that money can solve. So we
As long
will,
as it's someone else's money.
Your Honors, if I could, I'm sorry, I see I have a little bit more time. I do want to just address the request to use this superintendent's case to order changes at the Springfield District Court based on concerns about inefficiency. As you know from our brief, we respectfully suggest that this is not the appropriate vehicle to order, to entertain, much less to order changes at the Springfield District Court. Ideally, if that were to happen, everyone who participates in the administration of justice at the Springfield District Court would be involved, not just to the parties to this litigated appeal. The Springfield District Court is, despite being the most busy district court in the Commonwealth, it consistently meets and is in line with statewide averages in terms of disposing of cases within the time standards. And it is doing good and professional work, and we would respectfully suggest, that's not to say that they're not amenable or open to considering changes to the processes of that court, but this case respectfully is not the proper vehicle for doing so.
okay, thank you. We'll
Thank
take a
you, Your
morning
Honors.
break.
All right.